class is due diligence when buying and selling. And I love teaching this class because it is so useful to so many people in the transaction. It's useful to to my client, of course, whether they're the buyer or the seller. There are different reports that I do depending upon which party that I'm representing. But in either case, it's what do I do given my role in the transaction to provide the proper information to my clients so that they can make an educated decision when they're purchasing property. And it's not always just with the purchase. Sometimes it's crucial that the due diligence is done on the sell side as well. And we really don't know if that's the case until we do it. And what do I mean by that? Well, if you're selling a property, before you list that property, you as the broker on the transaction should be doing your homework and making sure that you list the property with the actual costs. So that could be the taxes. Maybe it's maintenance if it's a co-op. Maybe it is common charges if it's a condo. Maybe there's an HOA. Is there an assessment? If there's an assessment against the building, against this unit that you're selling, and you fail to disclose it, and now you take an accepted offer, I could almost guarantee you definitively that you're going to find yourself in a problem, because what's going to happen is somebody goes, they make their offer. They're making the offer based upon the information that you've provided in the listing and potentially at the open house. Now, I've seen situations where things like this do come up, and the broker may very well clarify it while they're at the open house, while they're with the potential purchaser, or they might not. So imagine this: offers accepted, deal sheets go out to the attorneys, buyer's attorney reads the board minutes, they get their questionnaire, they review the offering plan, they get all of the documents that I would recommend getting when we're doing due diligence. And now, all of a sudden, after they do all of that, they realize that there is an assessment. They find out vis-a-vis the managing agent for the building that there is a monthly assessment. And that monthly assessment, let's say for argument's sake, is $1,000. If your broker does not list that $1,000 assessment that a potential purchaser is going to be obligated to pay in the listing, I tell people all the time, don't expect to collect something that you don't list. If you leave it out, expect that your client, the seller in this case, is going to have to cover it themselves. Now, in this regard, another point that comes up quite frequently is that maybe the building doesn't care. We don't care who pays the fees. We just want to make sure that they are collected at closing. For example, let's just talk for a second about a transfer fee. I actually had a really bad situation that it's still ongoing. And basically what happened was, prior to the closing, we always, like I said, representing the seller, I send my client the due diligence. What does that mean for me? For me, in my practice, that means a few things. That means, number one, I go on to the Department of Buildings website. I look at DOB Now, and I look at the business information, and I look up the building and the particular unit that my client is selling, because I want to see if there are any violations or open permits. Is there a current certificate of occupancy? Is there anything that's going to create a problem once we get into contract? That's basically what I'm looking for. But you have to be very careful, because if a person does work at a property, but they do not get board approval, and or they don't get DOB approval, more importantly in this example, If they didn't apply to DOB in the first place, then how would there be an open permit? There wouldn't be. That doesn't mean that everything is all, kosher in the unit with respect to filings. All it means is that if they filed, they didn't pull a permit, or they didn't file plans, or they didn't file anything, they just did the work in the apartment. Maybe they did it with co-op board approval and not DOB approval. Whenever you're representing a party, there are two different equally important aspects of the transaction when it comes to work that might be done in the building or in a particular unit. And that is, there's a big difference between co-op or condominium board approval and the Department of Buildings board approval. Now, you can have a situation where the co-op or condo is granting you approval to do something, and yet the DOB won't allow it. I'll give you an example of that. An example might be a building downtown. This actually is a true story on Crosby. Loft-like building. Most of the units in that building built a loft. So they built a structure with a staircase, a sleep loft. Ceilings are very high. Most of the units have it. That type of structure would not be DOB approved, yet the building let everyone do it. And so now, what does that mean? Well, it means that if, let's just say, you bought a place and it had this illegal change or illegal structure, if you were to rent out the property and that person, let's say they're using your sleep loft that isn't a code, and now they happen to fall off, they get really hurt, the liability will be so much greater because you rented them an apartment that's not to code. Same situation, if ever you're going to rent out your place, and let's just say there's an illegal basement, maybe there's a bedroom in there, maybe there's a 3-fixture bathroom that was never filed for. Whatever the case may be, if you don't list it, if you don't apply for it, it's not going to be there. And so what we need to do is take it a step further. It's not just checking the DOB and HPD, Environmental Control Board, all of the administrative agencies to see if there's been any actions or open violations. It's much more than that. It's understanding what, if any, renovations have been done at the premises, and did the seller or all past sellers get permission from the board and from the Department of Buildings before they did that work? That's the question. Because if they didn't file, then you need to know what they did so that we can figure out if what they did was legal the way that they did it. And I'm going to preface this by saying that I don't care. It doesn't matter to me if work gets done and it doesn't go through the Department of Buildings, it doesn't get the board approval. I'm here to give you the facts. I give the facts as to what the law requires and what was done in this situation. And frankly, many times we don't even know. So now it's just a question of just transparency, just giving the information. Now, there is one thing further in that regard. That is that I would say over the past 5 years, it's commonplace that condominium and co-op boards have instituted a policy of having all purchasers sign off on a package, part of a package that's called assignment and assumption. It's an assignment and assumption agreement of all past work that was due at the property, and that any buyer coming in is accepting the fact that if the seller did something without permission, they're stuck with it. Take, for example, we have a seller who submitted plans to gut renovate an apartment. They were to gut renovate 2 bathrooms and take down a wall. Now, they did all of their work, They went through the building, they filed the alteration application, they submitted their plans and for permits to the Department of Buildings, and then they started their work. And while they were doing their work, as they were doing the bathroom, they decided, you know what? We'd like the toilet to be over there instead. Now, the plans didn't have a toilet moving. Now the toilet moves. By moving the toilet, you're changing, obviously, the plumbing line, the sewer line. And if that was not in the plans, if that was not part of the approval process, and let's just say your client purchases it, we close on the apartment, this building has the assignment assumption agreement, and lo and behold, a year later, there's a leak from your apartment, your client's apartment, down to the unit below. It turns out that there was an alteration application. You did agree to assume all past responsibility. But what ended up happening was when they went through the unit downstairs to see what happened here, where's the leak coming from, it turns out that it was only then that they discovered that the toilet had been moved. And so once that happened, the building will no longer take responsibility for the damages, and instead it's going to be the responsibility of the unit owner where the toilet had moved. Now, if nothing was moved and there was just a problem, then the co-op's going to take care of it. But now, and that's one of the reasons, really, that's the main reason why buildings have instituted that policy, because the co-op and condo boards don't want to be responsible when a shareholder or a unit owner makes renovations, doesn't submit, doesn't get sign-offs, and now they sell, they move out of the building, and lo and behold, there's all these problems. In fact, there are a couple of buildings, not many, a couple, that actually require an owner, a unit owner or a shareholder to remove all violations or close out open permits prior to the closing. Not a lot of buildings do that yet, but I do believe that that will be within the next year or two, that will definitely be implemented because it just makes it easier for the building. You know, one of the problems that you run into, though, is that buildings all have violations. It's very rare that you're going to come across a building in New York City, one of the the boroughs, or actually anywhere that doesn't have one violation to it. Generally speaking, they just do. It could be something very minor. It can be from peeling paint or cracked paint, or it can be something major like lead paint abatement throughout every window and molding in the apartment. So it could be extreme or not extreme. Now, this is all on your sell side. All of this discussion, the last 20 minutes, is just on the sell side of a transaction. It's making sure that you as seller are doing your homework. You're verifying the carrying costs. If the listing has been sitting for an extended period of time, you want to make sure that you update the listing. Generally speaking, buildings increase their common charges or maintenance after the first of the year. Some buildings, it starts in February 1, sometimes it's March 1, but after the first of the year is very common. And so if you had a listing that went on the prior year, it's crucial that you update your listing when the changes come out, when the carrying costs change, if an assessment gets implemented, when the new taxes come out. You want your listing to be reflective of the accurate costs to carry this unit, and you want to list who is responsible for what properly. Because remember what I said earlier, failure to list a cost that your buyer is obligated to pay will create a problem. I would say in 99% of the time, they're simply not going to want to pay it. They had their accepted offer based upon the numbers that you gave, and lo and behold, inevitably, what ends up happening is that the brokers end up kicking in to make up that difference. And that's not what you want. You work very hard for your money. You don't want to be doing that. Next, I'm going to turn to due diligence on a co-op and condo or condo when you're on the buy side of the transaction, because it's there that I go through a very comprehensive due diligence report, which includes reading the board minutes, checking everything on DOB and DOB Now, ordering the title report, and having the title company also search all of the municipalities and judgment searches, lien searches, the whole thing. We're also going to get a copy of the building's insurance, because if the building does not have insurance for some reason, then your client is going to have a really tough time getting insurance. Now, most buildings have insurance. That's not usually the issue. The issue is that it's not uncommon that the insurance may have lapsed and it wasn't updated. A lot of buildings these days, they keep their documents on board packager. That's a really good example where you might go on board packager, you might see that there's insurance, but the insurance expired 2 weeks ago. It wouldn't necessarily be updated yet. And so you want to make sure that before your client goes to contract, that the building is going to be able to get insurance on the property. We also obtain the purchase application, which is the document that gets filled out by the buyer along with the contract of sale and the monies that are due at the time of submission. We get a copy of the alteration agreement, which is the agreement between the co-op or condo and the unit owner or the shareholder, indicating what is going to be done at the premises, amongst other things. We look for an assignment assumption agreement so that we know what we have to warn our client about. We always get a copy of the accountant's letter indicating to us what portion of the common charges, the maintenance is for taxes as opposed to carrying the building, because we want to know, can we use part of that deduction? Now, with a condo, unit owners pay their own taxes. If you own your apartment as a condo, then you're paying your real estate taxes. The building will still tell you what percentage is tax deductible, because presumably there's a portion of taxes that is getting paid by the building. And so what portion of that, and so we need that information from the building accountant. We also look at the house rules. We want to also make sure that the house rules are the most recent house rules. House rules do get amended, and it's important to make sure that you have the most recent amendments. We need a copy of the offering plan. The offering plan is the big book that gets submitted to the Attorney General's office for approval in order to convert or build a building as a cooperative or a condominium. We look for all of the amendments. Amendments are documents, attachments to an offering plan that are filed after the plan is already presented and effective, because anything that changes from the original offering has to be set forth in an amendment. An example of that is when a developer is selling out a new development, they have to file indicating what units were sold and how many units are still sponsor held. So each time there's a sale, they then have to file an amendment. In order to have a price change, an amendment must be filed. We also obtain the questionnaire from the management company. The vast majority of buildings, you can submit your own questionnaire and pay a fee to the management company, which is generally speaking between $150 and $350. There are some buildings out there that have outrageous fees, making it completely cost prohibitive to obtain one, and which is really unfortunate. It's over $1,500. Who wants to pay $1,500 for a questionnaire, not even knowing if they're going to close on the building yet? Let's see. We always check the court systems also. We check the other attorney. If we're on the buy side of a transaction, I don't want to be giving my clients 10% deposit to the other attorney if the other attorney is not in good standing. I know it sounds crazy, but I've had probably a handful of deals in my career where in the context of the transaction, I figure out that the attorney is either suspended or disbarred, and they're sitting here still practicing law, having an account, they're going to take my client's money. No, if an attorney is not in good standing, I will not do business with that attorney. And I've had situations where I've had to have the other side of a transaction get another attorney because they're using an attorney that is not in good standing. The costs, we always want to be able to give our clients in our due diligence report what all of the closing costs are going to be. We get that information from the purchase application, from speaking with the managing agent, from submitting our personalized questionnaire. And we put all of that information together in a comprehensive written due diligence report. And I'm going to share one of ours with you now. The due diligence reports are not, they're not official documents. They're just my firm's process in the purchase of a co-op or condo. And frankly, I will say, I think I've taught most of the industry about doing written reports. Nobody was doing them for a very long time. I find it crucial, mostly because what happens is if something goes wrong and you didn't have it in writing, that's a problem. The first file that I'm going to work on with you, as far as due diligence is concerned, I'm going to work from 315 West 23rd Street. It's a co-op building. It's managed by Maxwell Cates. The report that I did, it really does give a comprehensive outline of the building, and so this is why I'm choosing this one. What I have up here is a due diligence report. I'm just keeping covered my client's name, and the apartment number is not really relevant right now. You're welcome to screenshot. You're welcome to see a copy of this. And if you ever have a deal in the building, again, the address is 315 West 23rd Street. And up here, right above intake sheet, it says checklist. The first page of my due diligence report is always a checklist of what it is that I want my firm to obtain before I'm ready to say to a client, here you go, we got all of your information together. This is what we found in the building. Now, that's not to say that I won't have clients sign a contract with a lot less due diligence than is indicated here, because that does happen. However, I make sure a client knows what my standard procedure is, because if they wish to deviate, there might be a risk involved. The intake sheet, I would suggest to every broker on here, every broker who's listening through the YouTube live stream, I would highly recommend that you have an intake sheet for all of your deals. You should be making sure that you give every client, once you are hired, whether it's the buy side or the sell side, you want as much information as possible that's going to be relevant for the transaction. What's relevant for myself as a lawyer is not going to be exactly the same as what's relevant for the broker. But a lot of it's going to be really close, because any one of you are capable of reviewing what exists at the Department of Buildings, whether it's on the DOB Now site or the old site. Anybody can learn to maneuver the sites. I actually teach a class on administrative agencies, and I specifically focus on the DOB because I think it's a fabulous site that owners and agents should readily go on to obtain information, to join classes that they do, podcasts that they do, be in the know of rules as they change. That's just one of the pieces, right? if you as an agent learn how to go through the Department of Buildings, when you get that listing, you don't have to wait for your attorney, Jamie, whoever, to give you this information. Instead, you've looked yourself. Maybe you don't find anything. So you're like, it is renovated, but I don't see anything filed. That's great information for your lawyer to have on either side. If somehow it didn't get to me before the deal is out there that renovations were done by the seller, but they weren't filed for, that may not come up at all before it gets to me. And so what happens is now it gets to the lawyer, and maybe the broker recommended to the seller that they get a lawyer, have somebody lined up, but things happen fast. They didn't do it. They didn't ask or hear the right questions. And lo and behold, they already have an accepted offer. And now me as the lawyer, I'm coming in here. I've sent them my intake sheet. I had my discussion with them on the phone to verify information. And it comes to me that this particular seller did renovate their place and they did not file for anything. So now what? Well, not filing doesn't mean that the work is bad or illegal. It just means that you didn't potentially follow the rules of the building or the rules of the Department of Buildings, which do require certain filings depending upon what kind of work is being done. I can tell you almost definitively that 99% of the time, if your deal involves electric or plumbing, you will need an electric and a plumbing permit. Now, getting back to the documents that I obtained, the offering plan, again, that's the book that gets submitted to the Attorney General. We spoke about amendments. A proprietary lease is a lease that all shareholders obtain when they purchase in a cooperative corporation. A proprietary lease, like a regular rental lease or a sublease, has an expiration date in it because a term of a lease is always required. Now, the whole purpose of the co-op, the use clause, it's for a residential building, and therefore they always get renewed. It's just that after 40 years or 60 years or 80 years, there may have been so much that changed that it forces the corporation to update their records. I do recommend that co-ops and condos do every 5 years revisit their corporate documents and certainly make changes, amend bylaws, amend house rules in the event that something very significant has happened. If you remember, for those of you who have done new development, the SALT deductions had changed during, at some point in time. Let's say it was around 2018, I think, 19, I don't remember exactly. But when that happened, it changed some of the directions in the offering plans. Same thing with changes in tax abatements. As changes get made, we now have to update any potential purchaser of a co-op who might get, or condo, who might get the offering plan from a sponsor as to what is different now than the original plan. And oftentimes that is going to be a change in law. In the event that you have a co-op and your buyer is going to be financing, then the bank is absolutely going to require the answer to certain questions. And let's just say the bank sees that the proprietary lease expires in 6 months. Well, no bank is going to loan on a building that the lease is expiring in 6 months without having a definitive understanding with what the co-op is doing before it expires. And so that gets investigated. The financials. Financials on buildings always go from 1 year to the next year. It's crucial that you have the financials on the buildings. It's not crucial that you have financials on a building from 5 years ago. It's crucial that you have financials on a building from last year, from the year before, maybe the year before that. At some point in time, you don't need to keep going back that far because the rules can be different. things have changed. What was bad or good 5 years ago may not be bad or good today. And so we want to make sure we have the most recent financials. Now, under business law, all corporations must file their financials, have audited financials done by the end of the first quarter. We already hit the end of the first quarter. Yet many buildings still do not have their 2024 financials. And so if that were to happen, we want to make sure that we get a copy of the final budget for the year in question. Board minutes. Board minutes are extremely important to read to the extent that they contain information that's up to date, current, and inclusive of all issues that are in a building. That will almost never happen. And so how important are minutes? Well, they're as relevant and as important as the information that's contained in them. And so it's never going to be one thing. It's never going to be, oh, you know, Jamie, can you look at the financials on this building and let me know if this building is good, strong? No, I can't do that. Why? Because one set of financials is not giving me that answer. You can have a co-op or condo building that operates in the negative every single year and still be a very strong building. I'll show you why shortly. Department of Buildings, as I said, I personally do the searches, my team does the searches, and then we order the searches from the title company as a just in case we miss something. HPD, violations, DOB, we're looking for all that stuff. Remember the tax deduction letter. Remember I was telling you that we need to know what piece of the maintenance or common charges is actually deductible. The purchase application, of course, we want to look at. We want our clients to know what it is that they're going to have to provide prior to them having to provide it, because it might take some time to get whatever the item is. Certificates of insurance, as discussed, you're not going to be able to get insurance on a particular unit if the building does not have its insurance. As far as getting insurance in a co-op or condo, it's an inexpensive policy. It's a walls-in policy, meaning everything from the walls inside, it's protected by your carrier. And most buildings, 95% of co-ops and condos require purchasers to get insurance. Some don't, but you're not going to be protected then. If, for example, your neighbor upstairs floods you and ruins all of your property, if it was the fault of the person upstairs and the board is not taking responsibility, right? Well, guess what? You're going to have a real problem there if you didn't have insurance for your personal belongings. Now, you might be able to go after the person upstairs insurance to pay for your belongings, but they're going to say, hey, wait a second, you should have had your own insurance and we wouldn't have been in this problem. So it's nonetheless, if the upstairs neighbor was at fault, more likely than not, the insurance carrier for your client is going to go after the insurance for the unit that caused the flood. Copies of lawsuits. Basically, we just want to know, is there any lawsuit pending or threatened that is not going to be covered by insurance? If a lawsuit is going to be covered by insurance, I'm much less worried about it. I don't need all of the details. Schedule A. Schedule A outlines how many rooms there are, what the monthlies are, etc. Financing, again, we always want to know, is the buyer going to be financing? If they are financing, there are three choices on a co-op contract. It's either going to be a cash deal, it's going to be financing, but not contingent on financing, or it's going to be contingent on financing. I personally do not believe in contingencies. I think that, it's very rare that somebody is not going to know whether or not they're going to get approved, and taking a unit off of the market for somebody that doesn't feel comfortable enough with their own financials, I wouldn't want a client to waste time. Now, with that said, what you might not have realized I was going to say is that even though there's a contingency, or there's not a contingency, or it's cash, we want to be very careful. We want to make sure when we're representing a buyer that should the bank fail to fund the loan through no fault of the purchaser and solely due to something about the building, maybe it's a new development and maybe it's only 20% sold and this particular lender wants it to be 40% sold. And so now all of a sudden we have our commitment from the preferred lender, but they won't close the deal. That actually happened to me on a couple of deals over at the Central a couple of years ago. Happened to a lot of people. It got worked out. The developer didn't make people close, so we did work it out. But the preferred lenders were no longer willing to finance because so much had changed. We got into the whole COVID time, etc. So now we want to make sure that even if it's non-contingent, as a buyer's lawyer, I still want to make sure that if the bank won't fund through no fault of the buyer, that my buyer can get their contract deposit back. And I will tell you, there is not one rule that I have when I'm representing a buyer that I don't do the same thing when I'm representing the seller. I don't believe in contingencies. I think my clients should know that they can get their financing too. I believe in funding contingencies on both sides. I don't think a buyer should lose their deposit if, let's just say, the sponsor didn't pay the taxes or they didn't renew the certificate of occupancy, etc. Now, I note in red on my due diligence reports that the closing is going to be on or about. The reason I note that is because it's a few times a year at least, somebody tells me that they're very upset because the closing date is not closing or happening on the date that the contract said. And so I then can remind them, as I tell them on the phone also, as it says it in the contract, but I highlight it in the due diligence report because it comes up that often. Either party can postpone a closing for up to 30 days most of the time. I want everyone to realize that there is no rule that says that a TOE letter must be 30 days. However, conduct and court cases have said that that is a reasonable amount of time, and so this becomes sort of the standard. However, there are plenty of exceptions to that. For example, we go to contract. Everybody knows that it's a time is of the essence deal. Well, if it's a TOE deal, then of course it's proper to serve the TOE. What if it's not a TOE, but now it's been postponed, accommodating the buyer? They were out of town. They don't have their H-1 visa. They can't get their contractor in there. They lost the power of attorney. Whatever the case is, we want to make sure that we have the time to close so that our client doesn't have a problem. And so there are certain things that we do to protect against that. Going on, address, we always need the address. We need the amount of shares. And I want to show you, sponsor unit, no, this is not a sponsor unit. The number of shares allocated to this particular unit is 159. That means that there are 13,757 shares in this building over 75 units. Now, if hypothetically the building needed to get a new roof and the new roof was going to cost $100,000, they would take the 100,000, they would divide it by the 13,757, and that would determine what the price per share is for any one particular shareholder's responsibility for the assessment to replace the roof. And that's how it is all the time. Maintenance gets increased. If there's a 6% increase, it's across the board for everybody. I always like to determine the last few increases in maintenance or common charges because I do believe that what a building has done historically is reflective of what we could expect of the building in the future. And here you can see that the increases have gone up and up year over year. Why? Probably for the same reason that all of our food went up, our rents go up, our expenses are all up because life is more expensive right now. We always want to know what utilities are included in the maintenance. Is there a separate charge or does it come with it? Here we know that the utilities are included. We know that there's a current assessment. It's not enough to know that there's a current assessment. We want to know, is the current assessment due now? Will it be paid off before closing? What is it for? In other words, what was done at this building that led to the assessment? And here we know that the current assessment was because the building was performing local law 11 facade work. All buildings more than 5 stories must comply with local law 11, which requires doing certain inspections at certain periods to ensure that there are no loose materials or holes or leaks at the building. I always ask for prior assessments just because I want a client to see, like, look, there was an assessment before this also. So as soon as that assessment ended, there was a new assessment added 5 months later. It went from $16.17 to $37.47. In this particular situation, management indicated that they just may keep the assessment going. So even though it covered the local law 11 work, the building sometimes will keep an assessment going because the building might just simply need money. The co-op condo tax abatement, it's very important just to understand what it is. It's an abatement that's given to buildings for units that occupy as their primary residence. They get a reduction of the taxes for that particular building. Now remember, a co-op is only one building. You have one block and lot. You have one tax bill. And therefore, what most co-ops do, most co-ops will not even give the abatement back to the shareholders. Instead, what most co-ops will do is they will institute an assessment to offset the abatement so that if the assessment is $3,000, they give an abatement for $3,000, it washes each other, vice versa. Now, if your client does not maintain the premises as their primary residence, they're not entitled to the co-op condo tax abatement because you must be a primary resident in order to qualify. Now, if you qualify, now does the building qualify? The rules have changed. You need to basically ask the building, ask management if they qualify for the co-op condo tax abatement. Buildings that are below a certain number of units or buildings that don't pay prevailing wages do not qualify for the abatement. On the condo side, the individual unit owners apply for their abatement. Now, generally speaking, once you purchase in a co-op, as long as you're living there, just year after year, it's going to continue. You're automatically going to get the abatement. And again, it will probably be offset by an assessment. The reason they do that, it gives them a number to assess shareholders who do not occupy as their primary residence. So any shareholder that it's not their primary residence, they don't get they're not going to get that abatement to offset the assessment. They're just going to be stuck with that assessment. And so whether you're an LLC entity that owns the property or whether you're a non-primary resident, you will not qualify for the co-op condo tax abatement. Flip tax. Flip tax is a charge that the co-op instituted at some point, comes off the purchase price in this particular building, again, 315 West 23rd. They require the seller to pay it. We want to be careful. We want to make sure that since the seller's paying it, that it goes into the listing. We make sure it goes into our due diligence report. Now the closing costs. These are all the costs that would be applicable to this particular building and based on this particular transaction or any transaction of the building, because your closing costs are going to be the same regardless of the unit. It might change in terms of the 0.75 of the price is going to be different depending upon the sale price will dictate how much the seller has to pay. We need to advise our client what they're going to have to do when they submit their board package and what gets paid now versus what gets paid at closing. Again, more costs involved here. Repairs. There are certain provisions from every offering plan and proprietary lease that are highly relevant. I quote them so that my clients know what the rights and responsibilities are with respect to these issues. This one being repairs by the shareholder, also known as the lessee. The lessee, as opposed to the lessor, is the co-op corporation. And it basically says what the lessee has to do. Renovations. If my client tells me that they're not doing any renovations, I'm still going to seek to get these answers, but I'm not going to delay the contract signing over it. The information as to whether or not the buyer is going to renovate, we obtain in our intake sheet, and then that tells us what type of due diligence we need to do. So here, the buyer had indicated that they're going to be renovating, and therefore we need to understand what's allowed, what's not allowed. Maybe my client wants to put a bathroom where there was a closet. That's known as wet over dry. Not all buildings allow it, some do. Some buildings don't let more than one renovation go on at one time. This particular building doesn't allow more than 4 at one time. That can be an issue. If my client intends to renovate right when they move in, that could be a problem. And so we had to discuss with them that you may not be able to. This particular situation, they're not going to renovate before they move in. It's okay. They'll move right in. Gas stoves still at this building. Washers and dryers are allowed, but they do need to conform to the building's rules. We always want to know whether there's storage, parking, or bicycle storage in a building. It's not enough to know if it exists. If it does exist, we must know, is there a cost? How is it owned? Is it licensed? Is it leased? How is it owned? How does it transfer? Very important. One of the biggest mistakes brokers make is saying that storage comes with the unit, when in fact it doesn't come with the unit. The buyer can license it if it's available. When somebody sells, it goes right back into the pot most of the time. Another big pitfall, moving. Tell your clients, don't move in the day of the closing. Why? Because we don't know what time the funds are going to hit and whether or not the building will let you move in that day. I always tell people, do not plan to move in within 24 hours of your closing. Alterations, just want to know what has to happen. Here, there were prior renovations, so we want to request the alteration applications. Special risks, very, very important part of any offering plan. It's where you will find if there are lot line windows, lead paint, asbestos. Any deficiency will be listed in the special risks section. Homeowners insurance, spoke about that before. Pet policy, again, what is it? Just want to note it. Subletting, is it allowed? Pet-a-terres, are they allowed? Don't assume that a parent can buy an apartment for a kid. You want to make sure that you find that answer out before you go to contract. Not all buildings allow it. Not all buildings allow gifting. Not all buildings allow purchasing in a trust or an LLC. I will tell you, most of the time, it's on a case-by-case basis, so your clients do want to be careful. There's no guarantee they can close in an LLC or a trust with a co-op. And so if that's really important, you want to kind of clear that up now. So when I have a client that wants a trust, I make them decide, are you going forward if the building won't close in a trust? Because I don't want to waste my time or their time. So generally speaking, we get them to agree, they're going to close either way. This way we can move forward regardless of the outcome. The budget, we spoke about that before, and the reserves. Keep in mind, buildings can no longer do reserve studies as a substitute for not line iteming, putting a line item of 10% for the building going into a reserve. The notes section are very important. That's what this all comes from. Percentage of what's deductible, legal action, owner occupancy, always important. How much financing is allowed? Were there any improvements done at the building? If the answers had been yes here, I would have listed when, what was done, etc. Any upcoming repairs or replacements. That's the indication on whether or not there might be another assessment. Local law 11 applies for all buildings more than 5 units, meaning 6 or more. Any problems in the building? We want to know about it. There you go. And board minutes, I just summarize them here after we read them. And that's the report. I'm Jamie Heiberger. This was Due Diligence. I hope you got a lot out of this. For those of you who may be listening on YouTube, if you want to see the video, you can also see it probably on my media site, and I'll also post it on YouTube directly once I have that. Have a great day, everyone, and do your homework, do your due diligence. Talk soon.